Good morning. You're Jon Willis. And so we were here before for sentencing. Mr. Willis had pled guilty to burglary of a habitation. There was a question about whether or not there was a murder charge pending or coming over in Calcasieu Parish. Charles? Lafayette. Sorry. And so what did you guys find out?
Okay. So I spoke with the detective out there. He referred to the prosecutor. Prosecutor said that there is a co-defendant. His case was sent to the grand jury. The grand jury, they don't call it no bill out there. I don't know what they call it. They no billed him on the murder, but they sent in a suggestion for manslaughter. So
on the
co-defendant.
Okay.
So the prosecutor told me that it's possible that Mr. Willis' case may go to the grand jury as a manslaughter, but he doesn't know yet. And he said they don't know until Mr. Willis gets to Louisiana. So there hasn't been anything filed on him.
Okay.
Judge, I left a message for same District Attorney Chris Landry on February 24th after we recessed from our last docket. I called back and spoke with his assistant who was going to give him another message. And I made multiple attempts yesterday to reach him and wasn't able to reach anybody at that number where I had previously reached them. So I made every attempt I could to let him know. I filled in his paralegal about the situation we had and said, hey, heads up, if you guys want to hold or you need a 10-day marker or something, it'll be from next Tuesday, meaning today. So
right,
those are the efforts I made. And I would suggest that out of fairness to the defendant, we if the court is inclined, we go along with the original plea of deferred. If
sure
they want to use it later, I'm happy to share my files information with them, but I don't think we should punish him with a conviction for something just because that may or may not be out there.
A Texas courtroom saw major developments as multiple criminal cases moved forward, including a burglary suspect.
Then you can write Ms. Holmes or get in touch with her or the court, and there's probably some ways that we can take care of this at the same time so that you're not doing some time and also on probation. Okay, but we'll deal with that when and if it happens. Okay. All right, so then in cause number 25, DCCR 1048, I'm going to find that you, and we've already gone over the pre-sentence report and everything. So I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, then this is an excellent opportunity, especially if nothing comes out of whatever happened over in Lafayette, because you do not have a felony conviction on your record. And if you successfully complete this probation, at the end, the case is dismissed. You'll never have the felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty. So you would become a convicted felon and you could be sent to prison for anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand? And I'm assuming there is a no contact.
Colette Richard.
What's the name?
Colette Richard.
Colette Richard. And so you're not to have any contact or communication with Colette Richard. And I understand that she's gone back and forth and y'all have gone back and forth. But unless you have my permission, which could happen if you get out and you're on probation and you're doing well, and she probably takes an options class or something like that. If y'all are planning some type of relationship, you're not, so we don't have to talk about that. Then don't contact or communicate her. If she tries to contact or communicate with you, don't reply, okay? Because she won't go to prison, you will, right? All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir.
Mr. Wilkerson? Mr. Holman, doing all right? It's all good. How are you? Doing very well.
Good morning, sir. You're Jon Jones.
Yes, ma'am.
And Mr. Jones has 4 cases, all on the set for trial to begin with jury selection next Monday afternoon. We have 25 DCCR 0523 charged with murder, 24 DCCR 2431 charged with unauthorized use of a vehicle, 25 DCCR 1352 charged with aggravated robbery, and 25 DCCR 1353 charged with robbery. And what is the announcement?
Judge, we're ready for trial. We just need to know which one is going first.
State's ready for trial, Judge. I believe we'll elect to try the murder first.
Okay. I will number the cases after
Use and just going, the offer was two's the max, going open to the court, because the state didn't want to piecemeal it, just to get that one out of the way, Judge. If you want me to do the paperwork on that, I can.
Honestly, I think it's probably, what I don't want to do, just based on the nature of that. I mean, all of those things, I guess, in punishment, whether convicted or not, could be used potentially as some types of extraneous offenses, given the proper notice. I really am okay with you not doing that. Let's just keep them all together. Let's see where we get. If it goes forward next week, potentially, then we'll kind of go from there.
Address it from there.
Yeah.
Thank
Okay,
you, Judge.
thanks. All right. I'll let you know after Doc get the numbers.
Okay.
All right, so hold on a second. Ms. French on Jordan Thomas.
Yes, Your Honor.
Good morning, sir. Are you Jordan Thomas?
Yes, ma'am.
And this is 24 DCCR 0487. Mr. Thomas is charged with sexual assault of a child, and 24 DCCR 2178 charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, on this one, we're going to ask for a 45-day reset. Me and Ms. French have spoken about it, and she wants an opportunity to speak with the family. And I still need to go review the video. There's not an offer in the file that Ms. French inherited. If I remember correctly, we had an offer on the ag assault, but not the sexual assault of a child. And so if we can get just that one last reset, I think we can be 100% ready to either move it forward on trial or plea it out if that's going to be a possibility.
I guess my only concern is I typically don't do 45 days. You're not waiting on any evidence that you know of in your file, DNA or anything like that.
Your Honor, the only reason we added 45 from 30 is because I am out the rest of the week from Thursday and Friday. And Mr. Wilkerson's schedule is that he's going to be in trial next week. So that takes 2 weeks off of our ability to look at these things.
Yeah, I'm not certain about trial. I've obviously got Mr. Jones in here, which I'll know more about today, but I also have a couple over in CDCs.
Right, so I'm going to do 45 days, but I'll make that notation that this is the final reset. So you guys get taken care of what you need to. We'll get an announcement one way or the other that next court date.
Yes, sir.
You can go back to Kayla.
Thank you, Judge.
Good morning. Are you Wacy Bork?
Yes, ma'am.
And Mr. Bork is charged in cause number 25 DCCR 1213 with theft of property. And what is the announcement?
Judge, I spoke with Mr. Bork, and as well as Mr. Nichols. We have an offer on this one. I do need to go over some more information, especially explaining, because it was initially a state jail felony, punishment range now, of course, TDC level.
Right.
I need to go back over there a little bit with him so he can understand the full range of punishment, his exposure.
Right. It looks like it'll be a third.
Third.
Okay.
Yeah.
So, Mr. Bork, I'll reset your case one more time. So, Mr. Lewis will be out there. He'll go over everything, what your options are, what your possible consequences are with trial, and things like that, what the evidence is.